So a very good morning to everyone. Welcome to LawPutra YouTube channel. So today we are going to talk about winding up of company and its procedures. So winding up of company is done in two methods. Either by filing an application or it is removed by suo motu basis by the registrar of companies. So this can be simplified and said in two ways. One, it is compulsory winding up, and one is voluntary winding up. When it comes to compulsory winding up, the registrar of company can do it on its own when it feels that a company is not fit to be functioning anymore, and it feels that the company is really inactive and it has to be struck off. So there is a rule which applies here. Section 248(2) of Companies Act, read with the removal of companies from the registrar of companies, Rule 2016, says that a company will be struck off from the registrar of companies if it feels that the company is no longer functionable and it is not fit to be further continuance of the business. So why is that the company is getting closed or winded up, or it is totally taken off? It is done because when the company doesn't file its compliances or its tax proceedings and every other filing for consecutive 5 years, if the registrar of company feel that the company is not obliging and it is not following the compliances of the Companies Act, it will be struck off. So hardly it will take 3 to 6 months for a company to be verified, and it will be under the purview, and it will be monitored by the registrar of companies to know whether it is actually carrying out a function. So the registrar of companies will automatically feel that this company is not fit to be in business when the company does an activity which is malignant, which is not right, and it is against the law which has been in prevalence of the India. So any company which comes under the purview of Companies Act 2013 should follow all the rules and regulations which is laid down by the Companies Act. So when a company is winding up, it can be done on two bases, as I earlier said. So whether it is done by the compulsory method or by the voluntary method, it totally depends upon the board of directors and the members and other shareholders who are involved in this company. When a company is barred, when the board of directors is barred from further starting any company, it is better for them to conduct a meeting and decide whether they should be completing this and whether they should continue it or shut it down. When a company is decided to be shut down, the board of directors along with the members has to conduct a meeting. So when a meeting is done, it is a general meeting in which the minutes will be taken and a resolution will be passed. So when the resolution is passed, the company has to submit the application for winding up to the registrar of companies. Once the request has been accepted, a liquidator will be appointed for calculating the values of the company. The liquidator's job is to make a statement which actually tells what the company is undergoing. So before the winding up procedure starts, the company has to decide what are the assets that are there and what are the liabilities that are there. So it has to pay the undue debts and other expenses which are in prevalence. So it has to also consult with the creditors the very same day of conducting the general meeting or the next day and decide what they should be paying to the creditors. When the creditors' rights are protected, they will stand along with the company and the company can be closed in a proper way. When the company does not voluntarily close, when it's under a loss, the registrar of companies will take a legal action and it will be a worse situation wherein the company will be closed abruptly. When a company is decided to be closed in a voluntary basis, it has to issue a notice in writing to all the members and shareholders. It has to be published in a newspaper both in English and a vernacular language, wherein if there is any objection or any opinion, it has to be taken in. The general meeting is conducted. Within 2 weeks, the registrar of companies will have to look into the issue and take up the issue. So the procedure of winding up starts the very day when the company conducts the general meeting, and within 90 days it will be shut down. So the company will be closed once when all these procedures are followed. There are a few documents which has to be submitted for the closing of company, and also few compliances which are to be followed, which I will be reading out to you. These are some of the documents which are required when a company is about to get wind up. So the following are the documents which I'll read to you. Certificate of incorporation of the company, memorandum of association, articles of association of the company, certificate related to the closure of bank account of the company, and copy of board resolution, copy of resolution of the creditor stating that 3/4 of the members have accepted, statement of accounts of the company, winding up petition form in WIN 1 and WIN 2, and statement of affairs of the company in the format of WIN 4, and affidavit of concurrence in format of WIN 5, and advertisement in the vernacular newspaper form WIN 6, appointment of provisional regulator in the form of WIN 7 and 8. Form STK 2, procedure for winding up a defunct or dormant company. This would only be used for the fast track procedure. So here the liquidator is really responsible, and he has to prepare the statement, and a rough draft will be made and it will be submitted to the registrar of companies. Once the registrar of company accepts the rough draft, it will have to be ready to wind up the company. So an approval is really necessary from the ROC for the liquidator to take an action and close a company. So when a company is about to get closed, the company's board of directors and shareholders have to conduct one another final call meeting, and they will have to decide upon what they have to do with the book of accounts, papers, documents related to the company. So this is a responsibility of everyone before a company is getting closed. So when a company is getting closed, all the lease agreements and contracts signed by the company will automatically stand cancelled and everything will be over. So the company, if it has taken any debt or any loan from the company, so if the company has taken any loans outside the company, it will have to pay it before it gets to close. So when the closure is about decided, it has to sell all its assets and value properties before so the company has to sell all its assets before getting it closed. So once the company decides to close it, it will be done in a proper procedural way, and it cannot violate the rules and regulations which is laid down by the ROC. So the major responsibility is with the board of directors, who had to decide when the company has to be shut down. So the company on compulsory shutdown, or when it done voluntarily, it actually has to go through all these procedural compliance, and it has to be strict in doing so. So a closure of company is a major part of dissolving a company. So the ROC will give the certificate where saying that this company will be shut down sooner or later. So the winding up order, which will be made to be sent to the company liquidator in the format of return, and it has to be sealed and signed. This has to be done within 7 days, and once the order is received from the registrar of companies, the company will be starting to closure. So the liquidator has the duty and responsibility to prepare a report which will be submitted in the general meeting, which contains details of assets, liabilities and other activities which is carried on by the company. Once this gets approved in the meeting, the liquidator is responsible to submit the same along with the certified copies of documents of the company to the registrar of companies. So once the registrar gives the order, the company will be getting into the procedure of closure, and it will be done. So as said, these are the two procedures: one, voluntarily winding up, and the compulsorily winding up. Once the compulsory winding up procedure is initiated, the company cannot take back or withdraw from what it has done. So it is a rare occasion when a company is closed on suo motu basis by the action taken by the registrar of companies. A company can be shut down even if it is given by a request by a third party or a state government or a central government. So it need not necessarily be done by the registrar himself, but it will be done through any third party who feels that the company is no longer functionable and it is really dormant. So kindly please do subscribe to the LawPutra YouTube channel. Let's get to meet in another video.